docket as case number 107401, Kelter v. Sokol.
Justices, may it please the court, Joseph Booth appearing on behalf of the appellant, Stephen Sokol. I'd like to reserve 5 minutes for rebuttal. And I was asked to remind the court that I've asked for permission to use an electronic device.
Permission is granted and 5 minutes request is granted.
Thank you, Your Honor. We were asked just a few weeks ago to provide to the court and respond to the inquiry as to whether or not this is a final order, and therefore whether or not this court has jurisdiction to hear the appeal. And I conducted a thorough analysis, and as I will further line out, my opinion is that this is not a final order, and appellate jurisdiction is not it was not conveyed to the court properly at the time that the appeal was docketed. And here's why. As pointed out in the order, the October 2010 journal entry left open this issue of whether or not Janet will be refunded or reimbursed for a claim of medical expenses that occurred during the pendency of the action. Historically, what had occurred was October 2009, the court issued what appeared to be a complete and final order. Both parties filed a 259 motion to alter or amend, reconsider. Mr. Sokol lost his motion. It's, according to the journal entry, summarily denied. Mrs. Janet then won her motion because one of her key issues, her first issue in that list, had to do with whether or not she would be able to be reimbursed for this sum of about $5,000.
This is
the court
motion,
directs.
excuse me, counsel, these are the motions on November 16th?
Yes.
The dueling motions that were filed on the same day? Okay.
Correct.
I'm sorry, I just missed the date. Thank you.
The dates in this case make a timeline very difficult. Often everything happens in October, but the year is different, so it's easy. Both parties filed on November 16th motions to reconsider, styled differently. Hers was a motion for clarification or reconsideration and has no statutory cites within it. His had the statutory cites within it and was more clearly a 259F motion. She won her motion. The court then re-characterized the journal entry, and what that did was it offered her to proffer further evidence and for this list of claims. That effectively, using my analogy that I wrote in my brief that I provided to the court last, the court had moved forward, issued a final order, but had not removed its finger from the chess piece, essentially. And so what occurred was this October 2009 order that was a final order suddenly becomes not a final order. And if we read 254B, it's very clear that when we don't have an issue, an order that resolves all pending issues before the court, the court still has leave to make any changes it wants to make whatsoever in the entirety of all the issues before the court, unless it's made the required finding under 254B. Those required findings were not made. There's no other comment made that we're going to go ahead and make this a final order now. In the interest of justice, we're going to go ahead and clear this up. The fact that Steve then turned around and filed a subsequent motion to reconsider after this order simply makes it back into the realm of trial practice at the lower court level. The odd thing about a 259 motion is you can have an order. It doesn't have to be a final order. You can ask the court to reconsider that order, and that's all part of the fair play within the lower court's jurisdiction as we work through and try to come to the finality of an order. Or you can have a final order and it trips into the issue of whether or not we have jurisdiction under 625102. And if it's a final order, that duration is stayed if we have a 259 motion, which is how we wind up with some of the dialogue that's discussed in the lower court. But when that order left open this issue of reimbursement. It's one of the many issues that was before the court, one of the many counts, and it has not been resolved at all. What occurred, it was not resolved between the October 2010 and then the final December order that's currently under appeal. The December order doesn't direct any further litigation about that or doesn't address that in any way. It goes on to discuss what was a myriad of other post-judgment type issues, because there were enforcements of other aspects of this, such as the child support that was going on, and indeed a modification for it. Janet filed a motion on October 12, 2010, asking for the reimbursement. On October 29, 2013, she requested a hearing on it, and in December of 2013, the court found at that point that it didn't have jurisdiction to hear this reimbursement issue, because that's part of the journal entry that had moved from the from the district court to the appellate system under 60-2103. So it had been docketed. What had occurred originally in the history of this case, it seems that when I go back and I look at the original docketing statement in fact expresses doubt whether or not there is a final order. It expresses the same doubt that occurred when they filed the notice of appeal. The notice of appeals includes a footnote. The footnote itself says, we're not sure that this is a final order, but we believe it is. So at the time that there was a notice before the district court, there was an opportunity for a dialogue about that. There was no dialogue. At the time it was docketed, there was also this expression of we believe, but we're not sure that it was a final order. And then the matter just simply marches on through appellate practice. And for whatever reason, after I look at it in the light of your question, I find it quite surprising that what I consider a remarkably austere panel at the Court of Appeals, some brilliant minds there, did not see the question that you're raising today.
So, Mr. Booth, where are we? I mean, this is your client's appeal and your petition for review,
right.
And you're telling us it was premature.
Premature.
So we should dismiss it.
Yes. We're at a footing where everything from the docket forward was in error. The statutory, obviously, as this court's better attuned to its jurisdictional prowess than I could ever speak to, but the most recent case I found on the issue is the NAC case from this summer. And we go straight into the idea that the jurisdiction is statutorily granted, and the statute has strict confines upon which it finds that jurisdictional footing. In the NAC, there was a second line under a child in need of care case that allowed an appeal that doesn't exist under the Kansas Parentage Act. There isn't anything that gives us, that I can find, that I can argue to ask this court to extend any kind of discretion, any argument of waiver. We have a notice provision basically within the notice of appeal that wasn't acted on, but that doesn't cure the statutory jurisdiction. The basic foundation of this case was in error.
And just so I'm clear, because it's not in the record that we have, you're telling us that after the notice of appeal was filed, there was some attempt at the district court to try to address this open issue, but the district court determined it didn't have jurisdiction over that issue because you had filed your notice of appeal. Did I understand that right?
There was a request to the court filed in, let me look at my notes here, October 29, 2013, she sought a hearing and had a laundry list of various motions. There were 5 or 6.
But that's after this notice
Right.
of appeal, so the
Correct.
case is up here.
Right.
Okay.
Then in a scheduling or status conference before the court, I participated in that conference. It was determined that we were going to go forward with the modification for support post-order, as you would normally in the case of a custody case and parenting. But that the court, there was a consensus reached that because that journal entry, and that order was under appeal, that the lower court did not have jurisdiction. So in the most hairline way, there was no, I think the proper way to phrase this request for hearing is to see whether or not the court was going to hear it. There wasn't an attempt to have it heard and insisting, and then that motion was denied. So what's important about that is part of the order that this court issued that I'm trying to be responsive to is that has that been resolved by settlement, by litigation, or in any other way since the time that you have on your record? And that issue still remains completely open and unresolved.
What is open? This case started in 2007, correct?
Yes.
It's 2014, near the end of 2014, 7 years ago, and all matters are still left open except the child has reached the age of majority at this point in time, correct?
Correct.
So those issues aren't there, except there's a dispute about what might be owed in past child support and that. But what are we talking about? All the property? Everything now still remains open?
By virtue of 6254B, yes.
Okay.
Because there is one of the many issues that has not been resolved, the trial court, at least in theory, could go back and reinvent the wheel.
Right. That's what I think that's your position.
It is.
Yeah. And let me understand one other thing. The briefs indicate that the trial court assigned this to a special master sometime in 2008, I believe, or maybe it was 2007. But that process took a year, and then there was a hearing on the special master's report. It said, and the briefs characterize it, the special master worked with the parties. What does worked with the parties mean? What happened with the special master? And again, we might not even reach it. I couldn't figure out what procedure the special master used. I understand your objections to the special master report, but what occurred with did special masters meet privately with the parties and just get paperwork? What happened?
In an attempt to answer as close to the record on appeal as possible, as opposed to all
What
other
happened?
rumor and innuendo.
Right.
In arguments post-judgment, there was an attempt to get a deposition of the special master. And there were some emails that were proffered as evidence at that point. And essentially what it appears happened by a review of the record is that the special master, who's well known as one of the better mediators in the community, took the process on by referral as a special master, but decided to begin in the mode of a mediator. And then if mediation failed, and this was what he had put in this email, if mediation failed, then he was going to adopt the cloak of a special master and go forward. My client alleges that he had contemporaneous oral objections, no written objections, no motion before the court to move in a different way. And that one of the key issues, probably the most key issue, was that he's assigned as a special master and commanded to appear as a special master. He's billing as a special master, but he never took the special master's oath. Therefore, he was never imbued with that authority. And where we have is this contradiction here. And it was my client's position that he wasn't, well, I think he, in hindsight, really wishes he would have written something down, that the objection would have gone to the special master. Once the special master has issued his report, then he has the opportunity to go back from the special master into the district court, which by this time has changed personalities. Judge Eisenhower has left and Judge Ryan is now on, and voice those objections. The special master then proffered their recommendation. Judge Ryan then looked at the recommendation and objections to the recommendation that were filed within the 253 timeline, and then without holding a hearing, issued this first October 9th order. And that prompted the litigation. So we have this problem with sort of a fundamental act that creates or doesn't create jurisdiction in recursive nature here. The same sort of thing is going on in this special master question, because it's our position that this oath issue is fundamental in establishing the jurisdiction of the cloak of special master.
Any further questions? Counsel, you're out of time. Do you need 30 seconds to wrap up for us? Do you think you've made your points?
Did we complete the rebuttal portion?
You've reserved some time for rebuttal.
Yes.
So you'll be coming back up. I just want to know if you wanted to summarize what you've told us so far.
No, I think we're fine.
All right, thank you.
May it please the court, Ronald W. Nelson on behalf of the appellee Janet Kelter. What a long, strange road it's been. Today we come to the point where now the appellant and the person who requested review says their appeal shouldn't have been. Answering the court's question, going back to what Mr. Booth talked about, I believe, and I think it's apparent from the record, that Judge Ryan believed that his orders at the first request to alter or amend were final, and that he excerpted from that one issue of how are we going to deal with the unreimbursed medical expenses, given the fact that I'm giving over to the mother, Janet Kelter, the monies from the trust or the Uniform Gifts to Minors account that Mr. Sokol had withheld and refused to turn over, so that it could then be determined what amount was outstanding for the medical and special needs expenses that those monies could be used for. Again, throughout the transcript of that hearing on September 23, 2010, Judge Ryan stated over and over, I want to get this final. I want this to be final. I'm entering a final child support order. This is the day that it begins. Anything that you do after this point, if you're going to do anything after this point, you need to file a motion for it. At this hearing, Judge Ryan specifically said at the very end, if there is anything else that you need to bring up, you need to do it within 10 days of today. And that's when the motions were filed by my client requesting reimbursement and requesting reimbursement of unreimbursed medical expenses and requesting a division of special needs expenses, again, which Judge Ryan had said, I'm taking out the special needs adjustment. If there are any special needs expenses, you have to ask for those separately. So again, I believe Judge Ryan believed that it was a final statement of the judgment. Anything else was going to be post-decree and was a totally separate matter.
Well, we're sort of in, this whole case, regardless of this particular, whether this one issue hangs us up or not, this whole case is about trying to find a final appealable order, regardless of whether it's after the first motion to reconsider or the second one or whatever. But how can we have any final order with those unreimbursed medical expenses still dangling out there? I'm not taking what you're saying, nor are we finding in the record anything that says that Judge Ryan certified what he'd done so far, so we can't look at an interlocutory appeal type of approach. So we need a final appealable order. And if that's out there dangling, we're done, aren't we? As much as we've done, I understand.
Right.
You guys have fought at the Court of Appeals. We've come here, we've done a lot of work, but we have to have a final appealable order to kick off our day here.
Absolutely.
And it doesn't look like we have that, and you seem to agree.
I don't know exactly how to answer that. And part of the reason that I don't know exactly how to answer that is, again, this has been a long, tumultuous trip for my client for Judge Ryan with his belief that it was. But I concede, Judge Ryan did not make the specific finding that is set forth in Rule 54.
and he needs to, and these unreimbursed medical expenses needed to be addressed before we could have a final appealable order. I mean, we all know what a final appealable order is, and it's got to be there, right?
Right.
So we're done. Okay.
Are there any further questions?
I see none. Thank you, counsel.
Thank you.
You reserve 5 minutes for rebuttal.
No further comment.
Okay, any questions of counsel before he sits down? All right, thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.